significant other maybe being detected because of his own personal situation. That, of course, would be allowed, but Counsel, you're not objecting to that, right?
I'm not objecting to that, but I want 2 minutes to finish my cross if it happens in the middle.
Standard number 886110B, State of Nevada versus Meta Platforms. We are continuing the injunction hearing on the matters from yesterday. Counsels for the state, would you like to make the appearances for today since it's a new day?
Good afternoon, Your Honor. Aaron Ford, Nevada Attorney General, on behalf of the state with my colleague, Mark Kruger.
Good afternoon, Your Honor. Michael Gayan, also on behalf of the state with my colleague John Springmeyer and David Slade in the courtroom. We also have a number of people on the Zoom today, Whitney DeGesti, Rachel Fulgham, Anthony Walsh, all from the Attorney General's office, and also Katrina Stark from my office, and my co-counsel, Brian Moore, and I believe that's it. And everyone on the Zoom will be observing only.
Okay, thanks so much. On behalf of defendants.
Good afternoon, Your Honor. Tammy Peterson on behalf of Defendant Meta Platforms, Inc. Also present with me in court this afternoon is Timothy Hester, who is admitted pro hoc vice in this case, David Sneed, who's also admitted pro hoc vice in this case, and Michael Ambrosi, who's also admitted pro hoc vice in this case. Just we have a number of people in the courtroom as well who are observing from the law firm and from Meta. I would just point out too, the witness who's on the stand is currently in the courtroom, so I just wanted to make that, just point that out.
Okay, do we need appearances from Lewis and Roper? Are you all doing individual appearances that you'd like to make?
Good morning, or good afternoon, Your Honor. Dan Wade, also for Meta. And in the courtroom today is Daniel Pulsenberg and Stephen Steele. And just as a heads up, I know it won't matter to you, but Mr. Steele and I have a conference call and we'll be leaving shortly. It's no disrespect to the court or the witness or counsel.
No worries, you know, more people more than welcome to do that. Obviously, you have other matters going on as well. Okay, everyone does. So at this juncture, I'm going to just handle a quick administrative matter. Could have done yesterday, but we'll take care of today. Scheduled for 4/18, motion to seal redact records, which was the state of Nevada's motion to seal and or redact portions of the reply in support of the motion for preliminary injunction. We didn't deal with that little administrative matter. The court had an opportunity under Supreme Court Rule 3 to review it. The court was inclined to advance if the parties are requesting under EDCR 2.23. Do you all wish to advance to today? Actually, I can really do it. I have to advance it to today, but we were considering things that we yesterday. Go ahead, please.
Michael Gayan on behalf of the state. Yes, Your Honor, we would like it advanced to today and hopefully granted.
Yes, Your Honor, we have no problem with advancing it today, and we don't oppose that motion to seal.
Okay, so EDCR 2.23 advanced to today, and it is granted EDCR 2.20 with the court doing its own analysis under Supreme Court Rule 3 and applicable case law prior to having its inclination for today's purposes. So it is so ordered granted. That means order EDCR 7.21, please to the DC 31 inbox. We can get that one taken care of. Got a couple of outstanding orders I know are heading my way, but you might have been busy preparing for this, so there's no worries. Okay, so that means we are, is there any resolution? My rosy colored glasses at its finest today, or so are we moving forward? Okay. The chuckles, does that mean no?
Well, Michael Gayan on behalf of the state, there have been some discussions, not resolution of the ultimate issue, but we have met and conferred on sealing of potential exhibits for today, and so hopefully it will make things go more smoothly.
Okay, so in that regard then, at this juncture, we were in the middle of the cross-examination of a witness from Meta. So at this juncture, would you like her to go back to the stand, or is there some other brief other parties the court should be aware of?
No, I think we're ready to continue examination. Ms. Davis.
So, Ms. Davis, would you mind heading back to the stand? Thank you so very much. Okay, the court's general process is, feel free to have a seat, and as I mentioned, I've got fresh water, right? Fresh water, find it if you need it. Thank you so much. The court's general process, unless there's a specific request by counsel, is just to remind the witness that they're still under oath unless somebody requests that the witness be re-sworn in. Is there any such request, or is a reminder sufficient?
A reminder is sufficient, Your Honor.
Meta.
Acceptable, bless, Your Honor. Thank you.
Thank you. So just a friendly reminder, well, forward reminder, that you understand you're still correct, even though it's a new date. I do. Thank you very much. Counsel, feel free to continue with your cross-examination.
Okay, good afternoon, Ms. Davis.
Hello.
All right, so I, actually, an issue on timing. I know we're moving.
Would you like an update of where each
Yeah,
sides
can I
are for
get a-
timing?
Can I get a quick update on that and just where we're at today?
I see what a wonderful team we got this morning.
Apologize for not thinking of that before
No
starting.
worries, okay. So it currently shows plaintiff is at 1 hour and 15 minutes and defendant is at 1 hour and 10 minutes. But I will tell you, I was really, do you all each want an extra 15 minutes because some of this, because the amount of things that each of the parties have, and since we're here this afternoon, or somebody requesting something different?
That would be fantastic, Your Honor. We'll take whatever time the court is able to
Is that
provide.
amenable to defendants? Because you,
Yes, Your Honor, it would be an additional 15 minutes for each side, is that?
correct,
Yes, Your Honor. Thank
you all want it? Okay, so each side gets an additional 15 minutes. Go ahead, counsel.
Okay, thank you, Your Honor. So, Ms. Davis, in light of that interaction with the court, I'm a bit pressed for time today, even with the extra time. But I'm hopeful that that time will be sufficient. But I'm, out of respect for the process and that time constraint, I'm going to ask a series of yes or no questions, and I would just ask that you listen carefully and respond with a yes or a no, or I don't know. And if you can't answer in one of those ways, if you could just let me know. Is that fair?
Yes.
Okay,
Thanks.
thank
Friendly
you.
reminder, yes, audible
Yes.
answers. I appreciate it's difficult when people are on the stand sometimes. Yeah, I always do need audible answers to get you a nice clear record. Thank you so much.
Thank you. All right. Isn't it true that you sat on the board of the National Center for Missing and Exploited Children, or NCMEC?
Yes, I used to sit on the board.
Isn't it true that you, Mark Zuckerberg, and certain other individuals from NCMEC met on June 24th, 2019?
I'm not sure of the exact date, but I believe I know you're referring to, and yes.
And by that response, do you mean you do recall there was such a meeting?
Yes.
And isn't it true that this meeting happened while you were on the board of NCMEC?
Yes.
All right. And also, isn't it also true that one of the topics for discussion at the meeting between you, Mr. Zuckerberg, and certain individuals at NCMEC, that one of the topics was end-to-end encryption?
The primary topic was end-to-end encryption. It was designed to give them an opportunity to share their concerns as we are moving to a new way of approaching safety.
Okay. And isn't it true in preparation for that meeting with NCMEC that Meta created a document to help Mr. Zuckerberg prepare for the meeting?
Yes.
If you could take a look at Exhibit 64, it's the very last in the large binder. And while you're, very difficult.
That's okay.
And while you're flipping there, I'd just like to put on the record my understanding of the agreement that you reached with Meta before arriving today, that Meta is fine with using this document in court as long as we don't put it up on the screen. We're able to discuss its contents, read from it, admit it into evidence without sealing and those sorts of things. I would just ask the council confirm that, please.
That's correct, Your Honor.
Okay, thank you.
Was there a stipulation to its admission as well, or just, you still have to go through the foundation for stipulating to admit 64?
I don't know that they've stipulated to admission,
We have not, Your Honor.
No worries, then go
but in
ahead.
terms of sealing, so just to facilitate the examination, and I appreciate the courtesy. All right. Isn't it true one of the purposes of Exhibit 64 that you have in front of you was to prepare Mr. Zuckerberg for questions he may get during the meeting with NCMEC?
Yes.
And isn't it true that this document, Exhibit 64, was produced by Meta during the state's investigation that preceded this litigation?
I don't know the investigation, I can't speak to that, I have no idea.
Do you recognize the Bates numbering on the bottom right-hand corner of the page that starts with MT-IG-AG?
Oh, pardon me, excuse me, do you mean this investigation that you're talking about right now, that we're here today?
The state of Nevada's investigation.
Yes, this is dated June 24th of 2019, so I assume that was before this investigation.
Right, and Meta produced this document in the course of the state of Nevada's investigation, which was in conjunction with other states' investigation that preceded the litigation that brings you here today, right?
Okay, yeah, I'm sure it did, I don't know what they're lawyers, but yes, yes.
Okay. Does Exhibit 64 look familiar to you?
Yes, it does.
Okay. And you see at the top, FB attendees/participants, Mark
Yes.
Zuckerberg,
Yes,
and Antigone Davis, that's you?
yes,
Okay, and you did attend this meeting, right?
I did.
If you could turn to page 4 of the document, please.
Yes,
Okay. Before I get to this question, is this a document you reviewed to prepare for your testimony today?
this is a document I've seen, yes, before my testimony today.
Okay. Did you assist in preparing this document?
I did.
Did you write any of the content in the document?
I'm sure I was, yeah, I'm sure, yes. I and others probably wrote the content.
Okay. Right, Your Honor, I would move for the admission of Exhibit 64.
Objection, Your Honor.
Being no objection, 64 is admitted, thank you.
All right, Ms. Davis, if you could take a look at page 4, about halfway down the page. The fourth bullet starts with, "We are looking at the digital spaces. Specific harms take place, town square or living room." Do you see that bullet?
Yes,
All right, and the sub-bullet under that, if you could look there, isn't it true that Meta wrote in this document for Mr. Zuckerberg, quote, "We know there is a specific risk to minors who are at risk of being identified in the town square and then taken into a living room by individuals wishing to harm them."
yes, that's part of what led to the work to block messaging of adults to minors, for example, and other work that we've done since this was written in 2019 to today.
Okay, was that a yes? That is what is stated
I
in,
think the first word I said was yes, yes.
okay. I'll just remind you of my request because of my time constraints.
Your Honor, I'd like to object to the counsel's instruction to the witness. It doesn't seem to me she's obliged to answer yes or no. If it's not a yes or no question, she can answer it.
It was a yes or no question, Your Honor. Isn't it true the document says this? If she wants to add editorialization like that, she can do it on redirect. But I'm asking yes or no questions on purpose. I'm on the clock, and I have a certain amount of material I need to get through. And I would prefer that she save the extraneous comments for redirect with her counsel.
A request to a witness isn't technically something you're asking for a ruling from the court on, right?
Yes, I am, Your Honor. I'm objecting to counsel's admonition to the witness because I don't think all of these questions can be answered yes or no. And I don't think it's fair to the witness to instruct her this way.
Well,
So I am objecting to it.
The court can't prospectively make a determination on something I have not yet heard. With regards to that last question, the way the question was phrased could have a yes or no without an explanation. So I have to deal with your objections on a question by question basis. With regards to the last question, I would need to overrule it. I'm not saying the witness should or should not have answered it with a yes or no, but if that one did lead to a yes or no, and so I do not see that that request would have been inappropriate with regards to that last question. Go ahead, counsel, next question.
Thank you, Your Honor. And Ms. Davis, isn't it true the term town square used in this passage that I just read means Meta's public platforms?
I'm not trying to answer easily yes or no. I think generally speaking, yes, I guess.
Okay. And isn't it true that the term living room, as used in this passage in Meta's document, means Messenger's end-to-end encrypted messaging?
I don't think, it means into private spaces, so town square refers to public spaces, and living room refers to more private spaces. But messaging is probably even more private than just a living room, so it refers to the more private spaces and more public spaces, yes.
Okay. And,
Sorry.
and those private spaces include Messenger's end-to-end encrypted messaging, right?
Yes.
Please look at page 6 of Exhibit 64. Now direct your attention to the first non-bulleted bolded heading. All right, isn't it true that Meta wrote in Exhibit 64 for Mr. Zuckerberg, quote, "You are locking kids in an unsafe place even if you build protections and locking us out"?
Again, this will be hard to answer just with a simple yes or
Well,
no.
let me ask the question
It's
again.
not Meta's words, those are designed to reflect somebody else's words.
Meta created this document, didn't it?
Correct, but those are not, this is not Meta's voice, so this was designed to say, this is what other people are saying, and then providing comments underneath.
Okay,
So, it's not a simple yes, I apologize, Your Honor.
sure. And those are the types of things you can clarify on redirect, Ms. Davis. I'm asking yes or no questions exclusively today.
Well,
And
but-
so I'd ask that you try to keep your answers to yes or no, unless I ask something that is not yes or no, because this is eating up my limited time. Your counsel can clarify those things all he wants with you, and that is how
Then
the
my answer
process
would have
works.
to be no, because those are not Meta's words,
Your
which is
Honor,
what you
may-
asked.
Your Honor, may I object? This is badgering the witness.
Okay, let's go back. If the witness doesn't feel that the witness can answer yes or no, same with any other case, the witness can say that that's not the type of question that can be answered, yes or no. And you can determine whether or not you wish to ask a follow-up question. With that last question, the court would not find that it was inappropriate for the witness to set forth that they could not answer yes or no. With regards to the badgering objection, the court doesn't find it's badgering. There's a difference of opinion with regards to an explanation, and yes, there is the opportunity for redirect, that further explanations can be given. The court's not to preclude someone from answering yes or no if they say they cannot answer it yes or no, then regardless of which attorney is asking the questions, can then see if they wish to ask a follow-up or they or not. You may continue, counsel. Go ahead, please.
Isn't it true, Ms. Davis, that someone at Meta wrote the words, "You are locking kids in an unsafe place, even if you build protections, and locking us out"?
Those words are written in a document by someone from Meta.
Thank you. And isn't it true that the word "us," second last word in this line that Meta wrote, refers to NCMEC?
Yes, because this was supposed to be a statement by what the safety organization's concerns were.
Okay, take a look at page 5, please. And the first filled in black bullet says, "We know prevention and detection is easier for some harms than others." Do you see that bullet?
Yes,
All right, and the first sub-bullet under that bullet, please pay close attention as I state my next question. Isn't it true that Meta wrote in Exhibit 64, in preparation for its meeting with NCMEC, quote, "We will never find all of the potential harm we do today on Messenger when our security systems can see the messages themselves," close quote.
that's what that states there, yes.
Okay. Please take a look at page 6. Again, flip back. And look down to the third bolded heading without a bullet. Starts with the word "users." Do you see that?
Yes,
Okay. Isn't it true that Meta wrote in Exhibit 64, quote, "Users want privacy but not at the expense of child safety from sexual exploitation. What proof do you have users want end-to-end encryption? Close quote.
I cannot answer that with a yes or no to the question that you have. Those words were typed by someone from Meta, but they reflect the opinion, the thoughts of others, not Meta.
Okay. Yesterday, when I was asking you questions, you testified that you had no knowledge of anyone in Nevada asking Meta to provide end-to-end encryption for minors, correct?
Correct.
Please look at page 7 of Exhibit 64. And the very top bolded heading, isn't it true that Meta, someone at Meta, wrote in Exhibit 64, quote, "You understand that you will degrade or interfere with law enforcement and safety capabilities," close quote.
Again, these are not Meta's words, these were the words of the concerns that we felt that Nick may have raised during the conversation.
And Meta wrote those words in Exhibit 64, right?
Correct.
Let me shift gears a little bit. Isn't it true that not all private messages containing CSAM that are sent on Messenger are reported by the message recipients, reported to Meta?
Can you just repeat the question? Sorry.
Sure. Isn't it true that not all recipients of private messages sent on Messenger that contain CSAM report those messages to Messenger?
I would assume that's true, yes.
And for those messages containing CSAM, which are not reported by the recipient, those messages are now protected with end-to-end encryption, right?
The content of those messages cannot be seen by end-to-end encryption.
And for those messages containing CSAM, which are not reported by the recipient, which are now protected with end-to-end encryption, Meta is unable to view the contents of those messages, right?
Meta cannot view the contents of encrypted messages.
And isn't it true that that also means that Meta is now unable to provide the contents of those messages to Nevada law enforcement in response to a valid search warrant?
Not if a user has reported, then we would have the content of those messages.
Right, but all of the questions leading up, we're talking about messages that were not reported. So everything but
the question you asked didn't ask that, but outside of the context of what I just said, the answer would be yes. But if users have reported, we would have access to that content.
Okay. And isn't it true that, take a look back at the top of page 7, the line that we just read, or looked at, about degrading or interfering with law enforcement. Isn't it true that this impact on law enforcement is what Meta meant when it wrote, quote, "You understand that you will degrade or interfere with law enforcement and safety capabilities"?
Again, these words weren't Meta's words. These words were words that we expected that Nick would say to us.
But isn't it true that the impact of Meta being unable to provide message contents in response to search warrants is what Meta had in mind when it wrote that the shift to end-to-end encryption, quote, "will degrade or interfere with law enforcement"?
I think it's what Nick had in mind, or Nick would think on that. Yes, that's why it's written there.
And written by Meta.
Written by Meta to reflect what we expected Nick would raise.
Are you familiar with Meta's white paper? It's been described as a white paper by your counsel. Do you know what I'm talking about?
Yes, I think, yes, I do.
Okay. Can you take a look in the smaller binder, set that, maybe don't flip that shut.
Okay,
Dangerous.
it's hard to get back to it, yes, I understand.
Well, I'm just saying, remember council, you can give one to the court, we still don't have one.
I thought we handed it. I
No,
thought
you all
we-
said you had different ones and you passed them back between yourself and none actually got it to us.
Oh, no, they have, you have the plaintiff's binder, right?
Sure, yeah, I have the plaintiff, I have the plaintiff binder, now I have the defendant.
Right. Thank
No
you.
worries, thank you so much.
All right, Ms. Davis, if you could turn to tab L, please. Okay. Is tab L the white paper that you had in mind when I asked about it a minute ago?
I think so, yes. I mean, without doing a long read of it, yes.
Okay, and Exhibit L on the title page is entitled Meta's Approach to Safer Private Messaging on Messenger and Instagram Direct Messaging, right?
Yes,
It's dated, it says first published April 2022 and updated September 2023, correct?
yes.
Isn't it true? Are you familiar with this white paper?
I am familiar with it.
Did you have any input on its content?
I'm sure that I did review it, yes.
Okay.
I did not write it.
Your Honor, I would move to admit Exhibit L, the evidence.
No objection, Your Honor.
I see that L is admitted.
Thank you. Ms. Davis, isn't it true that Meta's white paper here in Exhibit L contains none of the statements that we just went through from Exhibit 64?
Yes, one was written in 2019 and the other was written in 2022, so it's probably changes in circumstances, but I shouldn't say, I don't know for sure, but I would have to compare line by line this to that.
Does Meta's white paper in Exhibit L identify any of the 5 risks from end-to-end encrypted messaging on Messenger that we just reviewed in Exhibit 64?
I think that white paper tries to address the ways in which we dealt with or have tried to deal with some of the issues that are raised in L. Whatever this, not L, this document, the first document you had to look at.
Right, but my question is, isn't it true that none of the information in the 5 passages we read from Exhibit 64, particular risks and impacts on law enforcement from end-to-end encrypted messaging on Messenger, none of those specific risks or harms are described in Exhibit L?
I'm not familiar enough to make a statement to that effect, yes or no, on the stand here. What I do know about this is that this was designed to demonstrate the things that were done specifically to address the kinds of risks that are in this referenced here.
Would you like time to review Exhibit L to be able to answer my question?
If you want me to spend, it would probably take me quite a long time to read every line and check against every line in here.
Would you be surprised if none of the statements from Exhibit 64, specifically the ones we looked at, the 5 statements from Exhibit 64, are explained in the same way in Meta's white paper, Exhibit L?
I would expect them to be explained differently because they reflect actions that were taken to address those risks.
I have no further questions, Your Honor.
Redirect counsel?
Yes, briefly, Your Honor.
Do you want me to leave these open still?
Yes, you can leave them open. Good afternoon, Ms. Davis. Let me ask you to look back at Exhibit 64 in the big binder. In the
This
large
one.
binder in front
The
of you.
big binder.
You have it there?
Yes.
So you were asked a question on cross-examination about the statement that appears on page 5 of the document. And it's a sub-bullet at the top of page 5, and it says, we will never find all of the potential harm we do today on Messenger when our security systems can see the messages themselves. Do you see that statement?
I do.
Were there changes after this document was written that would change this statement in your mind?
Yes, and I think the bullets underneath indicate some of the work that we intended to do. So we have developed new detection technologies to identify different types of content to help prevent that kind of harm. So everything from detection technologies that have led to a 6-month period, the removal of 90,000 accounts, 21,000 groups in a different 6-month period. So the idea here was, as the bullets below it indicate, we would invest in other ways to try to detect that content.
So after this document was written in the middle of 2019, how much did the company invest in safety issues?
Well, the number that I've given before is $5 million in 2023, but between 2016 and 2023, we invested $20 million.
And was a significant part of that investment addressed to this question of finding potential harm on Messenger?
Absolutely, yes, sir.
And so would you say it is accurate today, after the work was done over these years, is it accurate today that we'll never find all of the potential harm we do today that we can see in the messages themselves?
I think that we will probably be able to prevent a significant amount of that harm. We'll continue to be able to find a significant amount of that harm with the increase in reporting. I can't do an exact comparison.
There's, if you look down to the middle of the page, there's a heading that says reactive. Do you see that?
Yes.
What does that mean when it says reactive? And then there's statements underneath in bold.
Just if you get these questions or these statements from Nick, these are some of the things that you might want to.
So the statements that appear in bold under reaction on page 5 over to page 6, page 7, and page 8, were those meant to reflect the statements in bold? Were those meant to reflect the statements that Nick would be making?
Correct, yes.
Were they meant to reflect what Meta believed?
No.
Let me ask you to look at one that counsel asked you about, top of page 7, please.
Yes.
Where it says, you understand that you will degrade or interfere with law enforcement and safety capabilities. Do you see that?
Yes.
What was that statement meant to reflect? Was that statement meant to reflect what Meta believed?
No, it was meant to reflect what Nick believed.
And then could you explain what the bullets are underneath that bolded statement?
Well, it was statements that were designed to reassure Nick that we intended to continue to try to be supportive of law enforcement in their efforts to safeguard children, that we would be taking numerous steps to still be in a really good position to continue to try to be supportive of the work of law enforcement.
And you described work that the company did from 2019 at least up until 2023. After that work was done, would it be accurate to say that Meta had degraded or interfered with law enforcement safety capabilities?
From our perspective, we actually think that we've made our platform safer, that we're reducing crimes across the platform by protecting with encrypted messaging, and we'll continue to be able to play a role that is supportive of law enforcement's work.
And what is your view on the quality of the information that Meta is able to provide today with law enforcement?
I think for example, we'll still be able to provide user reports which will have that content. We also will still be able to provide law enforcement with important metadata, like who the sender and the message is, who the recipient is, when they message, how frequently they message, the last IP address from which they message, all things that are important to investigations.
And do you have a view about whether the net effect of that has improved or degraded the quality of what Meta provides to law enforcement?
Objection leading.
Sustained.
Could you comment on what the impact has been in terms of the quality of information that it can provide to law enforcement?
I know that at this point in time, law enforcement feels that it gets numerous reports that are not actionable that are, that they asked to be defined as informational, so they will not follow up on them. And I think with what we're doing now, much larger percentage of our reports will be highly actionable.
Let me ask you to go to the small binder, Exhibit L that you were asked about by counsel. Could you go into the 5th page of the document? It's got a number at the bottom, number 168. Do you see that?
Yep.
Let me point you to the second full paragraph on the page. Could you read the first sentence of the second paragraph that begins, "and while"?
And while the vast majority of people using messaging services to connect with colleagues, friends, and loved ones, a small number of people will attempt to abuse them to do harm, including to young people. Should I keep going?
No, that's the sentence I want you to read.
Okay.
Is that discussing the risks associated with end-to-end encryption?
Yes, it is.
Let me ask you to look at page 177. There's at the top of the page, the second full sentence that begins, "while the HRIA," do you see that?
Yes.
What is the HRIA?
These are human rights impact assessments that BSR did. I think it's the Business for Social Responsibility did.
And there's a phrase that begins after HRIA where it says acknowledges. Do you see that?
Mhm.
Could you read that into the record, please?
Reminder, can't have uh-huhs.
Oh, sorry.
I know it's a natural
I'm
response, but we just
so
need to
sorry.
follow.
Yes,
It's a
I will
natural
read
reaction,
the
no worries.
reaction. Yes, and yes, I will read it. While the HRA acknowledges the possible risk of use of end-to-end encryption to facilitate the trafficking of adults and children to share CSAM or to plan terrorist attacks, unless these risks are mitigated in many of the ways we explain in this paper, it ultimately concludes that extending end-to-end encryption across messaging platforms will provide vital safety protections for vulnerable users and other rights holders around the world.
Do you agree with that statement?
I do.
And could you explain in particular whether the risk referred to there on end-to-end encryption is identifying one of the potential harms associated with it?
It's definitely identifying both the risk and the potential harm, yes.
And was the work that Meta did that you've described over your testimony in relation to the last 4 or 5 years, was that work intended to address those
It was
risks?
designed to intend those risks, yes.
Thank you, Your Honor. Thank you, Ms. Davis. I have nothing further.
Recross counsel?
Briefly, Your Honor, thank you. Ms. Davis, isn't it true Meta's investment in safety that you just described for Meta's counsel were intended to benefit users of Messenger in Nevada?
It was intended to benefit all users, including those in Nevada, yes.
And they were also intended to make Nevadans want to continue to use the Messenger platform, right?
The safeguards,
Yes.
yes.
And in any of the passages that counsel just had you review in Exhibit L, Meta's white paper, did it include or describe the risk of locking kids in an unsafe place?
Repeat your question, please? Sorry.
Sure. In the 2 passages you just reviewed with your counsel in Exhibit L, Meta's white paper, did either of those passages describe the risk from locking kids in an unsafe place?
It didn't use the phrasing in this first document, which is what I think you're referring to, but it addresses the same risk that was meant by the phrasing that we were using mixed words in the first document.
I have no further questions, Your Honor.
We should redirect.
Nothing further, Your Honor.
Is this witness excused? And if so, excused for the rest of the preliminary injunction hearing or not? Counsel, for you called witness, I'll ask you first.
Yes, Your Honor. From Meta's perspective, yes.
Thank you.
Yes, Your Honor, thank you.
Appreciate it. Please watch your step on the way down.
Thank you.
Mr.
Should I just
Excuse.
leave these here?
Yeah, you could just leave the binders there. Thank you so much. Just like I said, please watch your step on the way down. Okay, so then at this juncture, since we're in Meta's case in chief during the preliminary injunction hearing, Meta, would you like to call your next witness?
Yes, Your Honor, we would like to call our next witness, Mr. Ime Archibong. In line with your report, the discussion that we had at the end of the court, he will be appearing remotely as opposed to in person with agreement by the state. We informed them of that yesterday.
And since there was an agreement by the state, the court was going to allow that he just needs to, before he gets sworn in, authorize that the clerk here in Clark County, Nevada can swear him in, but he's not, I can't say the four corners of Nevada, I'll say the unique shape. So we just need that first, okay? So please, can you, but feel free to come, are you doing it from there or you're doing it from the podium?
I will do it from the podium.
No worries, you can do it from wherever you want. Okay, so then he needs to turn on audio visual, please.
So
Once he
we were
speaks,
asking
I'll do it.
him, given the rule on witnesses, he was not on the Zoom as of yet, and so we are communicating with him to ask him to join the
Okay.
Zoom at present.
Okay, thanks, Ray.
And once he starts speaking, I can do just to. There it is.
Just testing that people can hear me.
Yes.
Okay, so, counsel, the first step is, you, as we discussed, first need to, because witness is located outside the state of Nevada, is that correct?
That is correct.
Okay. The first thing is the witness needs to agree that he can be sworn in and is subject to the laws and the jurisdiction of the state of Nevada for purposes of this hearing only in order to appear for the witness remotely.
Mr. Archibong, did you hear what the court has explained about agreeing that you will be subject to the, you will agree to be sworn in under the laws of the Clark County District Court that we are in now?
Yeah, absolutely. I appreciate the court's flexibility too on location for me.
Sure. No worries. Okay, so then at this juncture, Madam Clerk, please swear the witness.
Raise your right hand. You do solemnly swear or affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth under pain and penalty of perjury.
I do.
Could you please state and spell your name for the record?
My name is Ime Archibong. First name is I-M-E. The last name is Archibong, A-R-C-H-I-B-O-N-G.
Thank you.
Feel free to,
May I proceed, Your Honor?
of course, go ahead.
All right. Good afternoon, Mr. Archibong. Can you hear me well?
I can hear you well, yeah.
Thank you for appearing. Could you please introduce yourself to the court?
Yeah, my name is Ime Archibong. I am the Vice President of Product Management at Meta, but also the Head of Product of Messenger at Meta.
And how long have you worked with Meta?
This is year 14 for me, so a little while.
Can you please explain for the court what your roles at Meta entail?
Yeah, as Vice President of Product Management, I'm one of maybe a little under four dozen or so kind of senior product executives at the company that are thinking about our product experiences. As a part of that, maybe a subset of that team, maybe 5 to 10 of us also run the product management function for the entire company. So end-to-end thinking about what it is to build products at a billion-person scale at our company. And as the head of product for Messenger, product manager for Messenger, I think.
You just cut out. Hold on a second. After the word messenger, not clear if maybe you turned your head or something, but it cut out for a word or two. So counsel, do you want to re-ask the question or what do you want to do?
I'd be happy to re-ask the question. Could you explain for the court what your roles at Meta entail?
Yeah, as Vice President of Product Management mentioned, there's maybe a few dozen of us at the company, and we're responsible for the products across the company in our portfolio. More acutely, I sit on what we call our PMX team, which is a subset of that group that is really thinking about the product management company for our product management function and for the company. And then as head of product for Messenger, I think more acutely and specifically about Messenger, the service, and ensuring that it's a desirable, kind of feasible, viable product that we are building and billions of people are using.
Can you just provide a brief description of the Messenger service?
Yeah, the history behind the Messenger service was, we saw the secular shifts probably in 2008 from people wanting to share across their Facebook network in a public way to a private way. We built a service called Chat on Facebook.com. We were a desktop experience back then. And as technology shifted right around 2011 or so, we knew that we had to build a service and experience that was built kind of first and foremost for a mobile device. That's when we transitioned the name to Messenger as a service and made it an app that people could download and use. And over the course of the last now almost 16 years, it's a service that over 1 billion people use to privately communicate with their friends, with their families, with the communities that they're a part of, the groups that they're a part of, and so on and so forth.
And about how many people work at Messenger?
In the Messenger organization directly, it's probably close to 1,000 folks. But the reason why you see me kind of doing this is, in addition to the Messenger organization, we clearly work with the legal team, the integrity team, the ops team, the finance team, so on and so forth. So I bet across the entire company, we have a few thousand people that feel responsible for the Messenger service and how we put that out to the world.
I want to shift gears and talk a little bit about end-to-end encryption. You understand this hearing is regarding end-to-end encryption?
I do understand that, yes.
And you're familiar with end-to-end encryption?
I am.
What's your understanding of why Meta wanted to implement end-to-end encryption on Messenger?
There's layers to it, and I had alluded to earlier the societal shift, the secular shift towards private communication. As more and more of us as humans' lives move to a digital space and our communication moved to digital spaces, it was clear that people wanted to make sure that their private communication was safe and it was architected in a way that even the service provider, in our particular case, Meta, couldn't see that communication. That was kind of first and foremost in the why. We read pretty deeply that people should have access to private communication. From a user perspective, we saw that the industry had, pretty fundamentally moved in this direction too. As I sit here now, this is an end-to-end encrypted experience. I think across the web, more than 95% of websites are end-to-end encrypted or at least secure. The people who had built kind of mobile-first experiences like an iMessage or a Signal were end-to-end encrypted by default. So we had to play a little bit of catch-up on this particular set because users' expectations have really shifted towards encrypted experiences and safe experiences. Those are some of maybe the fundamental reasons why we started to make the shift and the change.
I apologize, counsel. I meant to do this before Mr. Archibong started. Can we just, Your Honor, is it all right if we have the witness, because he is testifying remotely, just confirm that he has no other documents open on his screen or messaging devices or anything like that at his disposal? I'm not accusing him of anything. I just want to make sure that the integrity of the process is upheld.
It's a standard request that happens, as you know, when people appear remotely. Mind asking the witness?
Completely fine. Mr. Archibong, do you have any messaging, other applications, any form of communication open and available to you while you're sitting here on the stand?
With a small caveat that if his significant other maybe hadn't been texted because of his own personal situation, that of course would be allowed, but counsel, you're not objecting to that, right?
I'm not objecting to that, but I want 2 minutes to finish my cross if it happens in the middle.
I can guarantee you that the bags are packed and the car seat is loaded, so I can at least give you that. But I can confirm there's nothing on my desktop open other than this Zoom meeting. I wanted to make sure that I don't mess with the bandwidth or anything, and hopefully the performance is pretty good. But then your assumption is right. I do have my mobile device here to my right-hand side, so if my significant other was to call me and say that it's coming, I'm at least alert and ready to go.
Thank you, counsel. Thank you.
Go ahead, feel free to proceed.
Thank you, Your Honor. You were getting at it a little bit in your last answer, but I wanted to follow up and just make clear, is the move to end-to-end encryption something that's unique to Meta?
No, by all means, no. I think that we're playing catch up in this space. If you look at the industry, iMessage, which clearly iPhones are used by north of 85% of young people here in the United States, has been end-to-end encrypted since its inception, 2011. In fact, I think just 3 months ago, they're putting out white papers of how they're pushing the boundaries on encryption and going even further, preparing for kind of the next generation, building frontier encryption protocols. And then the rest of the marketplace too, Signal, Telegram, each of them have their own kind of versions of encryption, whether it's end-to-end or not. It varies, but the marketplace default is definitely encrypted private safe services.
Now, when did Meta first launch end-to-end encryption with Messenger?
We launched end-to-end encryption as a feature in Messenger in about 2016. And it was 2019 where we kind of declared that it was time for us to move beyond feature and really make it an experience that is the default experience for the app and the service.
I want to understand the distinction that you just drew. On the first point, you described it as a feature. What do you mean by that?
So Messenger had been available since 2008. There were hundreds of millions of people that were using it by 2015, 2016. I'm not quite sure the exact number. And because, again, we saw that the industry had moved in this direction, we were getting kind of the feedback from society and people that this was a shift that was underway. We offered it as a feature where you could go to the Messenger service. If I was having a conversation, per se, with my wife, and I wanted to maybe share, health information about the baby that we were expecting, we wanted to do it in an encrypted, kind of safe, private way, I could toggle a feature, and it would pop open a new end-to-end encrypted thread for me and my wife to communicate to.
So at some point, there was a shift after that. I want to understand the second piece. You described default end-to-end encryption. What were you describing when you said default end-to-end encryption as compared to that?
Yeah, it was the kind of the acknowledgement that the secular shift had happened. What I like to share with people who weren't along with the journey is like a good example here is I think you probably all remember when caller ID was a feature. I surely remember kind of growing up, and we didn't have money to have caller ID, but AT&T offered it and had a friend, so you could run over to the little caller ID stand and you would see who was calling before you pick up the phone. But back then, still, definitely greater than 50%, maybe 90% of the phone calls that reached your home when you picked up not knowing who the caller was. As we sit here today, I don't know anyone who picks up unknown calls that hit their phone. So the secular shift that happened with a privacy feature like caller ID is essentially what we experienced and what we saw from an end-to-end encryption standpoint by 2019. It was a nice feature to have, but society expects this, people expect this. We need to build this by default. All of the other services and messaging services out there in the marketplace by default had this feature, and we needed to catch up pretty quickly.
Now, when did Meta begin rolling out end-to-end encryption as the default for personal messaging on Messenger?
We just started in Q4 last year. It took us quite some time to even be prepared to get into a position where we could roll it out in a default way.
Let me follow up on that. What was involved in making that transition and rolling out default end-to-end encryption internally at the company?
A lot. We announced it in 2019 that we were going to start this journey. We knew that it was going to be a fairly challenging and complicated journey. There was both the product strategy of how to actually execute this type of transition in a way that didn't break the experience. If you think about it, I'm not quite sure what the number of people exactly were at the time in 2019 that were using our experience, but it's safe to say that it was hundreds of millions, if not even over 1 billion people by then. That their experience that they had enjoyed and that they loved and that kept us at the top of some of the app stores for such a long time were not going to be broken as we made this fundamental shift to bring up our product experience, honestly, our kind of security architectural experience, to what the industry norm was and what the industry standard was. So there was product considerations. We had to rebuild over 100 different product features for this new architecture and this new stack. We wanted to do it clearly in a way that was going to continue to adhere to our kind of company principles of keeping our community safe and protecting privacy, and that had to go through a bunch of rounds of thought and thinking of how we had to execute in this new kind of encrypted world and architecture that we were building towards.
One of the terms that you used in your declaration, and what you use now, is code base or code stack. Could you just explain what that means as relevant to what we were just talking about?
Yeah, the internet is made of 1 zeros, I like to say, and for anyone who isn't like a software engineer, those 1 and zeros are programmed, and they are lines of code or just think blocks of text that you throw into a compiler and executes that code. But that's what renders web pages, that's what renders applications. Again, we were in a world where you're building services at our scale and our size. That code base, which are just lines and lines of code, very quickly get into the thousands, if not even tens of thousands, if not even millions of lines of code. So what I'm talking about is going through those, it's called like millions of lines of code, and thinking about how to re-architect them or how to rewrite them in a world where it is encrypted by design. Maybe outside of the software piece of that, when I say something like encrypted by design, it really is for over a decade or so, the way that Facebook and Messenger and some of our other services have been, you have a client, which is a website or a browser or a computer or your mobile phone talks to our servers, right, where a lot of the information was being run on and pushed to the client so you can get those rich experiences. When you move to an end-to-end encrypted world, what you're really talking about is getting rid of the billion-dollar servers that we've been using to run our systems for over a decade and trying to deploy the same product experience from a client to client, from a mobile device to a mobile device. And there's a lot of complexities and challenges that come with that, both on the code base and clearly how you actually end up architecting this.
All right. So broadly speaking, what's your understanding of what Meta invested to make this shift to default end-to-end encryption?
If you look at the Messenger team and the investment that we've made just purely from, I'll start with maybe our engineering capacity. We're talking about hundreds and hundreds, if not even 1,000+ engineers over the course of, I guess we cleared this journey in 2019. We're sitting here in 2024, and we're still in the rollout. So 5-year commitment, hundreds and hundreds, if not even over 1,000 engineers. From a product perspective, again, I'm not going to try to draw direct correlation between the two, but when we declared this journey and we knew that it was going to be the bulk of how we invested our talent, right, our really talented engineers in order to make this transition, we've gone from an app that was top of the app stores to one that has fallen below on the app stores because a lot of the investments in engineering capacity wasn't going towards rich product features to keep up with the marketplace. So there's a little bit of like you're sacrificing some of your leadership position, if you ever had one, in order to make this transformation with the hopes that, once you get to where society's expectations are, you can get back out in front. And so product sacrifice and a lot of technical and kind of focus sacrifice for us.
Now, let me ask you this. What's your understanding of users' expectations regarding end-to-end encryption with Messenger?
Objection, Foundation.
The way the question's phrased, what's his understanding of users, I'm gonna have to hear it, and then I'm gonna have to address your objection afterwards, so he has a basis for it.
Yeah, and Your Honor, that's all I would like a foundational question of how he obtained any understanding of users' expectations. That's all. Thank you.
We can do it either way. I can listen to it and potentially strike it. If he doesn't say his foundation, we can ask a foundational question. Counsel, it's your choice.
I think the easiest is just to allow him to answer the question, and then we can proceed from there based on what has happened.
Yeah, if I understood the question right, it was how did I understand whether users or what their expectation was around end-to-end encryption. I go back to, again, the primary job of a product manager at at a company like mine or within our industry is to understand what users want and what they desire from our products. The work that I do involves me talking to users, often on a day-to-day or weekly basis. If not me, then working really closely in conjunction with what we call our research team, our user research team, whose primary job, again, is to ensure that we understand what true, I always say human needs are, but people needs are. Many of the product principles and the design principles that we as a company have always kind of adhered to, especially with our foundation being about driving human connection, is understanding what those human needs are. So with that as a backdrop, I go back to, again, like we've experienced, we run research, we ourselves are out there talking to people, and it's very, very clear that there was a big shift that happened in the 2010s, early 2010s, again, we're playing catch up here, that people's expectation was that their private communication channels, be it a message channel, be it a website that they were putting financial information into or uploading a picture to, was one that was secure and one that, technically, ideally was underpinned by some encryption or end-to-end encryption technology. One of the things I put in my declaration was just last year, I was up for a work trip in Seattle, and the Uber driver, I was doing my user research by asking the Uber driver what type of messaging experiences and features were missing for him right now, and he said, that thing that I experience on some of my other things like WhatsApp and iMessage, it's I was like, encryption? And I was like, this can't be real. I was like, give me a couple of months and hopefully I'll be able to roll this out to you. So those are the signals that I end up taking, that I end up getting, and that direct me in the product organization to build what we built.
Okay, bundled somewhere in the answer, there was his foundation, so I will remove the objection, because it's Uber driver, there's other examples of how he has his information. I take it with that limited version. Go ahead.
Thank you, Your Honor.
And remind you, cognizant as much as we're getting very long answers, and fairness to everyone on the time frame. Go ahead.
I will be very mindful of my time. I want to speed along. Now, in this proceeding, you're aware that the state has raised concerns about barring Nevada users that are under 18 from end-to-end encryption. Are you aware of that?
I'm aware.
Can you just describe some of the challenges in identifying users who reside in Nevada from Meta's perspective?
Yeah, I think location verification is an industry-wide challenge. It's definitely a challenge that, as I sit here right now, I know that we Meta have, and from a messenger perspective, as someone who's thinking about the product that I have too. The challenges are accuracy. Challenges are people move and people aren't static, right? People are constantly moving out of different jurisdictions or different states, different countries. Challenges are technical challenges. There's technology that people can put on their phones to obfuscate their location. So those are a couple of different flavors of the challenges that I think that it presents.
Now, let me just focus on this. To the extent that the company, Meta, would try to restrict end-to-end encryption from Nevadas that are under 18, what would be the burden of doing so from a technical perspective with Messenger?
I mean, layered on top of the location challenges that I just mentioned, there are going to be age verification challenges. That is another kind of industry challenge that's understood and that's well known. What signals do I have to truly verify someone's age? I don't have a birth certificate. And that, I think, in itself, like layered on top of the location challenges, is kind of fairly difficult. I talk about the non-static nature of us as human beings as we move from place to place, and I think that's non-trivial. We clearly age up too. So as people age and move from being a youth to a minor, present some product challenges, and then ultimately, when we run a service at our level and our scale, the complexities are there. How do I handle a teen talking to their grandmother on the East Coast? How do I handle a teen talking to their best friend who just went to boarding school on the East Coast. How do I handle a class of teenagers that go to France for 2 weeks over the summer for a class trip? There's just a bunch of different product and transitional challenges that introduce a lot of risk when you start to try to pull something off the SL.
I want to get back to the points that you were making about code stacks. To the extent that Meta tries to have an encrypted and unencrypted version of Messenger to be able to provide users in Nevada under the age of 18 with a different experience, what would be the challenges related to the code stack for Messenger?
I mean, there's multiple challenges. I mean, there's the obvious one of trying to maintain 2 code stacks. You're talking about code stacks that have hundreds of thousands, if not even millions of lines of code. How do you keep feature parity between the two? How do you keep safety parity between the two? That would be a worry that I would have. How do you keep backwards compatibility parity between the two? That would fall on us and just feels largely daunting. As a person responsible for the product, I don't know how I would ever compete in the marketplace with other folks who by default are maintaining one particular code stack and driving that forward in their with their goals. So yeah, there's just I think there's a lot of complexity. This idea of the burden of trying to perpetuate hold 2 code stacks just doesn't seem feasible to me as a product leader right now.
Would you have concerns relating to the viability of the end-to-end encryption for the circumstance where you have 2 systems going at the same time?
Yeah, absolutely. I mean, I think anytime that you introduce complexity into a system, you are introducing opportunities for bad actors to exploit that particular system. So I have that worry. Yes, there's a number of different worries that I would have if I had to maintain two systems and 2 stacks.
With the court's indulgence, just one moment. No further questions.
Issue cross-examination.
Yes, Your Honor.
And
Could we have a time check?
that's exactly what I'm double checking on.
Just one second, I got it.
It was counsel, you were at, plaintiff's counsel was at 99 minutes. And partway through that
We
testimony.
were at 1:31 before we started. Just one second. So 1:55.
I think we're talking about.
Defendant, 1 hour and 55 minutes for
Okay,
defendant.
I'm doing it into minutes, okay.
Okay, so 15. I mean, 2:15.
No,
Wait,
you
60,
did-
100 and,
100,
Yeah,
okay,
15.
where we're at is 99 minutes for plaintiff and 115 minutes for defendant. So that means defendant, yes, has gone over their time frame. Does anyone have a different time frame that somebody thinks is different?
Michael Ambrosi, I have been keeping the time, and I believe we started today with the state having used an
Your Honor, I'm sorry. That is wrong, because I just added those last 20-some minutes on to the state, and it should have been defense. So I apologize.
Okay, hold on a second. We're gonna pause for a second.
Yeah.
Sure.
I mean, I get you. It's just-
Hopefully this isn't counting against me.
I'm just
I'll just sit down so it
I'll
doesn't.
tell you exactly. Okay, let me figure it out exactly. It was just the last,
Okay,
it was just
the
that.
short answer is the state's number shouldn't change. The state was at 99 minutes because you were at an hour and 15 minutes and then.
No, that's right. So the defense is,
I think that should be
it
correct.
is correct. The defense is 115. I did add it.
Yes, defense is
I wrote down
115.
plaintiff, but I added it to defendant. So now you're right. I don't know what time you guys
According to
started.
the official
We
records.
started at 1:59:54 and ended at 2:22, 2:23:59.
So for my count, we have 8 minutes left and the state has about 10 minutes left. I don't know if that matches. I've been doing it by minutes left, the countdown, as opposed to the count up.
I don't know. I mean, I have exact times you guys all started and finished, all the way down.
We had, as an end of day yesterday, 1 hour and 15 minutes from the state, and 1 hour and 10 minutes from defense is what we had. The state then used 24 minutes today, which got it to 99 minutes, what we showed.
Actually, Your Honor, they used 35 minutes today from,
You disagree with my official court report,
Well,
counsel?
Listen, I feel
With
like
some
a book-
companies-
right now I feel like a
Post,
bookkeeper.
okay.
So,
Revoke his prod.
Your Honor, as long as we're somewhere close, I'm not
Counsel,
that
we're not gonna
concerned.
spend a lot of time on this, honestly, we're talking a minute here or two, you're wasting more
I'm
time,
not
regardless of
concerned.
timing of minutes.
24 minutes, they used to say.
I believe Mr. Sneed was efficient with his direct. I'll be efficient with my cross and hopefully redirect with it. I mean, this is the last witness, right? So,
We have no further witnesses after Mr.
Okay.
And
I'm
then
not,
I-
I'm not on the record as being.
Okay, so we're gonna go back on the record, and realistically, counsel, we're gonna just get you each taken care of. If somebody thinks somebody is overusing their time, then we're going to address it. But realistically, unless one of you is complaining, then, right, raising an objection, it seems to me that at this juncture, everybody agrees it was 1 hour and 15 minutes yesterday to 1 hour and 10 minutes. And yes, you used 24 minutes earlier today, and at one point, partly through the testimony of this witness, defense had used 28 minutes and then added additional time. So that's what we're utilizing as a general standpoint. But counsel, why don't you start your cross-examination?
Okay, I'm back on the record now.
All right, so now we're gonna get back on the record. Counsel, feel free to commence with your cross-examination. Thank you so very much.
thank you, Your Honor. All right, good afternoon, Mr. Archibong. Can you hear me?
Actually, yeah.
Great, thank you. My name is Michael Gayan. I represent the state of Nevada in this matter, and I just have a handful of questions for you this afternoon, and hopefully you can get back to your family and other business.
Thanks.
Okay. Quick question. Was your Uber driver that you mentioned a minor?
No, I don't believe so.
Okay. And was he in Nevada?
No, he was not. He was in Seattle. So,
Okay.
Washington State.
And isn't it true that just a few months ago, in December of 2023, end-to-end encryption on Messenger required a toggle on switch to activate?
You're saying, did it require a toggle to switch to activate?
Yeah, someone had to turn it on. It was not the default setting, correct?
It was not the default setting. December is when we started rolling out the default setting.
Okay, so prior to December of 2023, isn't it true that someone, a user of Messenger, would have to go into the settings somewhere and toggle on end-to-end encryption for a message before having that feature available, right?
We launched the toggle in 2016, so people had the option. So 2016 to roughly late last year.
And I believe I heard you testify when Mr. Sneed was asking you questions that Meta has not completed or has not fully rolled out end-to-end encryption on Messenger yet, correct?
That's right. As a service, we started in late Q4, and we mentioned that it was going to take months to roll out.
Mr. Archibong, isn't it true that Meta Platforms, Inc. has registered to do business in Nevada?
That I do not.
Objection. For two reasons. One, there's no foundation that this witness has any information regarding Meta's registration in Nevada, and also scope. This is beyond the scope of his direct examination.
Okay, I thought there was an agreement between the parties that the state was not gonna call Meta's two witnesses because Meta's witnesses were gonna be here and called by the state. Was that not an agreement between the parties?
I didn't have an understanding that there was an agreement between the parties regarding questioning relating to personal jurisdiction in this setting. I don't believe there had ever been an agreement that would happen.
Wait a second. Counsel, state your position, and no, this is not count. Looks the idea, remember, you all had an agreement that you were gonna split the time. We had X amount of time, given what a workday was and given all your arguments and all the other aspects. So Don't worry, everyone's
Thank you.
getting more than enough time than you normally get. The court fully is appreciative of the seriousness of the issue, the complex and the depth of the issue, so everyone's getting more than sufficient time from this court's perspective, so don't worry, we're focusing on getting everything out so everyone has a fair and full opportunity to be heard. So counsel, did you have an understanding, or do you agree or disagree with Meta? I have to address the outside the scope.
Your Honor, thank you. I do disagree. The Meta's registration is in the party's briefing. Had I called Meta's witnesses in the state's case in chief, I would not have, I don't believe, received a scope objection. The foundation, I mean, he either knows or he doesn't know, and he can say, and we can move on. So I don't
You heard
think,
the answer, he doesn't know, you understand you're objecting about somebody who's already said that they don't know. The court's gonna rule on the objection if you'd like me to, but you understand he's already said he doesn't know.
I understand. I wanted to make sure to assert that we would have an objection with regard to questions that are down this line. And I wanted to make sure to do it with regard to the first question, so as not to waive my opportunity to address that issue.
I need to circle back, because there was a statement by Mr. Gayan about whether or not the witnesses, right, the two witnesses were going to be here, right, with regards to whether they were going to be called or not. And then there was a statement that was made, well, if they're going to be here, then you're not going to call them in your case in chief. Now, whether this court did not hear a specific agreement under EDCR 7.50 on the record, as if it were memorialized, on the record, sorry, EDCR 7.50, you can make an agreement on the record without memorializing it in writing. That's what the court was referencing in the EDCR, which I'm sure local counsel are fully familiar with. But I just need to know, was there an express or an implicit agreement between the parties, or is this going to follow the quote funnel approach, meaning cross is limited to direct? I have a minute or two just to have each party's understanding. Go ahead.
well, Your Honor, Michael Gayan to the state, I think it was implicit when I raised it yesterday that I was prepared to call Meta's two witnesses in the state's case in chief to elicit testimony if necessary, and they assured me that it was not an issue and that I could question them now instead of having them potentially called twice in the case. So I did not understand that I was going to be limited in the way that Mr. Sneed is objecting.
Counsel, your position?
Well, there's, I think, two issues that are here. One is the direct and cross-examination issue. I do think in that meeting confer that Mr. Gayan had mentioned yesterday, we had discussed the prospect of cross-examinations being limited to the scope of the direct, and that was in my note back to him following that, in terms of identifying issues that we had both talked about as being a part of how this proceeding would run. But besides that issue, in terms of when to call them, we did make clear that we were going to have them available, we were going to call them, but I don't think that changes the run of the scope issue that's here. And then second, besides that, the question about personal jurisdiction is something that we had an argument about, we addressed before going into the preliminary injunction stage, and as I understood it, Your Honor wanted to proceed with the preliminary injunction hearing and address the question as to jurisdictional discovery separately and apart from what was happening here in terms of the witnesses that were here.
Let me address what you have a misperception from the court. Remember, this court, and people who practice here a lot would know if the parties want to handle something different or separately and want to handle it in a particular order, this court is generally fine to do so, right? Because parties know their cases and what the parties want to do in the best interest of their cases. You all presented the court with a list, a joint proposal for handling preliminary matters. Included in said joint proposal for handling preliminary matters, number 2 was personal jurisdiction, which is why the court asked yesterday whether or not you wanted to address arguments on personal jurisdiction, fully acknowledging that you all have in April a pending motion to dismiss that had jurisdiction, but since you raised it in your opposition, did you all wish to have that addressed because you put it as number 2 on you all's own joint proposal for handling preliminary matters? And at the end of said argument, the court did say that it said can move forward with regards to preliminary. I'm paraphrasing myself from yesterday. I said that we could move forward with a preliminary injunction because realistically, even though there's an assertion by Meta with regards to what the court can and cannot do with an assertion of personal jurisdiction, since personal jurisdiction was raised in the opposition, it is part of the preliminary injunction motion because it is part of the opposition arguments with response to the motion for preliminary injunction, which meant the court was moving forward and addressing all issues. The court's initial inclination with regards to potential discrete jurisdictional discovery. You all had two different viewpoints on that, so the court was moving forward, and even, I believe, made a comment that maybe it gets resolved during the course of hearing all the witnesses' testimony. And so therefore, from this court's position, unless Meta is saying that they are removing their arguments on personal jurisdiction out of their opposition, then this court has to conduct the full preliminary injunction. The full preliminary injunction would include addressing issues raised in your opposition, which then were addressed in the reply, which would include the personal jurisdiction issue in the context of a preliminary injunction, in the context of it being raised in opposition. So that's what from the court was doing, so that part, I'm not carving it out separately. At you all's request, you wanted it quote as a preliminary matter, so I was initially going to address it that way. And at the end, you all had very different viewpoints, and so it got bundled back into the preliminary injunction. I said I was considering your arguments that you handled initially as part of the preliminary injunction for the court making its ultimate ruling on a preliminary injunction addressing all the arguments and issues raised in both the motion, opposition, and reply, which is all three, as well as the amicus briefs, which initially were documents, but now were agreed upon amicus briefs for the court's consideration, so the totality of everything's getting considered. That's from the court standpoint, right? So this court views this all part of preliminary injunction hearing. That being said, the separate issue on whether or not you're following a standard cross-examination has to be within the limitations of direct examination unless there's expressed agreement by the parties. Otherwise, that's why the court was asking that question. It seems like I'm hearing two different positions on that, but realistically, you understand that your witness can get recalled in the case is at the end in redirect. If you want your witness to be sitting here longer and getting recalled another time, then that's really up to you all, but I need to know if there wasn't an agreement, then I have to sustain the objection for outside the scope. And then you have the ability to recall this witness right after they conclude their case in chief in your redirect case, right?
Well, thank you, Your Honor. Sorry, Counsel.
May I?
Sure. Just make one comment. Yesterday, when I raised this before we started taking any evidence, the intention of that is the state did not want to be prejudiced by waiting to call Meta's witnesses, and whether I specifically called out this issue or not, that the intent was that we would not be prejudiced and we could ask the questions if we needed to.
Which I don't see that you would be prejudiced since you could recall this very same witness again, right, in your, after their case closes, and unfortunately that means, or fortunately, who knows, maybe the witness wants to stay here longer versus doing his own personal things, but that's really going to be up to you. Since I do not have an express agreement on the record, you know under EDCR 7.50 where this court needs to do it, which is why I was asking you either expressly or implicitly you all had an agreement.
Your Honor, I will withdraw my objection so as for us to move forward and not require multiple steps in terms of having this witness wait longer and allow the question to proceed at this time rather than waiting for another juncture.
Okay, does that meet your needs, counsel?
Yes, Your Honor. Thank you,
Then please
Counsel.
proceed with your next question. Go ahead.
Mr. Archibong, can you still hear me?
Still got you.
Okay, great. All right. I believe you said that you didn't know, but let me just make sure.
Yes, all that
It's
color
clear.
back and forth was on the I don't know. Go ahead, please.
But, so I'll just re-ask it because it won't take long. Isn't it true that Meta Platforms, Inc. has registered to do business in the state of Nevada?
It's definitely not my core job, so I couldn't answer that. I don't know.
Isn't it true that Meta Platforms, Inc. has not registered to do business in all 50 states in the United States?
Can you ask that question again?
Sure. Isn't it true that Meta Platforms, Inc. has not registered to do business in all 50 states in the United States?
Again, just outside of my scope of responsibility.
Okay. Isn't it true that Meta intended to comply with Nevada law when it launched default end-to-end encryption on its messenger platform?
One more time, can you answer that, or ask that?
Sure. All right. Is it the volume or the pace?
No, I can hear you, I'm just trying to make sure I don't miss words.
Sure.
Okay.
Isn't it true that Meta intended to comply with Nevada law when it launched default end-to-end encryption on its messenger platform?
when we launched end-to-end encryption by default on our Messenger platform, I mean, I think about a platform that is used globally, a platform that's used by over 1 billion people in most corners around the world, and definitely across the United States, and all states included that. And we do everything lawfully, so.
So is that a yes, that Meta did intend to comply with Nevada law when it launched default end-to-end encryption in December of 2023?
And not having walked through every single, I'd say, state's law and jurisdiction, what I can say is that we build our products lawfully, but I never sat down and looked at Nevada law per se in this world.
Let me ask it the other way. Did Meta intend to violate Nevada law when it launched default end-to-end encryption in December of 2023?
And we roll out our products and our services in a lawful way.
So is that a no? Meta did not intend to violate Nevada law?
I don't build products to violate laws.
Okay, thank you. Isn't it true that Meta takes steps to grow its number of users on the Messenger platform?
Ultimately, if a product is desired by people, our hope would be that they would use it, that they would tell their friends and family about it. When it comes to private communication, clearly, you can't talk to yourself on the Messenger platform, so naturally you see some organic growth happening. Sure,
But isn't it true that Meta actually takes steps to try to grow its number of users on Messenger?
I get excited, yes, when our users are telling their friends that this product is great and it grows over time.
Right, but my question is, isn't it true that Meta takes steps itself to attempt to grow its number of users? I'm not asking about word of mouth. I'm asking about Meta taking steps to try to grow its number of users.
It's hard to define steps. I don't know what that exactly means. We build products, we put them into the app stores. My hope is that users download them, and a lot of users download them and love them. So if that's what a step definition is, which is that we're building products, then yeah, we're building products that we hope lots of people use.
Isn't it true that Meta takes some affirmative action to attempt to grow its number of users on Messenger?
And I don't have a clear definition of affirmative action here, so that's what trips me up a little bit. We build products. We definitely want them to be discovered by people. And if running a marketing campaign that Messenger is social, is exciting, and is expressive, and is a tool that you should be using, then the answer would be yes then. But again, I'm not quite sure what steps definition is.
Sure, okay, thanks for that answer. That does provide some information. So let me ask this. You, as the head of product Messenger since March of 2023, and based on the testimony you just provided, isn't it true that Meta takes steps, including an advertising campaign, in order to attempt to grow its number of users on Messenger?
It's probably a bad example because we haven't run an advertising campaign, unfortunately. But ultimately, yes, as the person who's responsible for the product, my hope is that this product is used by a lot of people over time. I'm proud of the products that we've built, and I want to see it in people's hands. So ensuring that they can find it, that they can discover it, that they can share it with their friends is definitely a part of my agenda, especially given in a marketplace that is pretty competitive.
Isn't it true that Meta employs people to attempt to expand Messenger's user base?
Again, I go back to, we have, nearly 1,000 people and probably, many more that are thinking about what success looks like for Messenger. And for us, that is, we are demonstrably solving a user need and doing it well. One of our North Star principles as a company is to try to serve everyone, right? Everyone who uses our tools. So, I think everybody every single day shows up to try to, build a product that is used by a lot of people.
Is it your testimony, Mr. Archibong, that Meta relies solely on word of mouth to grow its number of users on Messenger?
No.
So what other than, so isn't it true, based on that testimony, that Meta does other things besides word of mouth in order to grow its users on Messenger, correct?
Building the product in itself, again, is a step, or is doing something in order to put, a service into people's hands. So again, if that definition, if that foundational definition of why I show up every single day kind of checks the box for you, then that's how I think about it.
How about issuing the white paper that you described in your declaration? Is that a step that Meta took to hopefully grow its number of users on Messenger?
No, I'm not quite sure how many. Those white papers tend to be focused on the folks that deeply care about our encryption technology, safety experts who we've worked in conjunction with over the course of the last couple of years to explain the steps that we've taken to roll this out. But as I sit here right now, there's no indication that I have or that I've ever thought that that is something to grow users.
Is the white paper intended by Meta to help maintain the number of users it has on Messenger?
And I go back to what I said a little bit earlier, like societal expectations are here. Like we're playing catch up right now. I'm having to convince people that we are, building at the level of, safety standards and encryption kind of standards that society has already set. We're playing catch up. So my hope is that people see it and understand that we're meeting expectations, and that's our plan to do so moving forward.
Mr. Archibong, respectfully, and I know you weren't here for Ms. Davis's testimony, but I'm asking exclusively yes or no questions. And if you have lengthy additional things you'd like to add beyond the scope of my question, you're welcome to do that with Mr. Sneed on the redirect. But we are on the clock, and I know the court is being very patient with counsel, but I have specific questions and I'm looking for answers. And if I ask a yes or no question, I would appreciate yes, no, or I don't know, or some explanation for why you cannot answer in that way. But if you have information that goes beyond the scope of my question, I'd ask that you reserve it for redirect, and your counsel can elicit it from you at that time. Okay?
Sounds good.
Okay. All right, the white paper we were just talking about. Isn't it true that Meta published the white paper, at least in part, to address safety issues surrounding end-to-end encryption in Messenger?
White paper was published. We speak specifically which white paper? There's multiple white papers.
Sure. Do you have defendant's exhibits with you? I was told that some binders were shipped to you.
Yeah, it looks good, but I have not opened them yet though, so should I open them?
Sure, yes. I'm looking for this, hopefully they're in the same binder setup, but defendant's exhibits have letters and they're in a smaller binder. It's like someone really secured that box.
We instructed him not to open the box until he was on camera.
Security matters, analog and digital.
And exhibits.
So I have State of Nevada versus Meta platform.
Yeah, that looks right. That's the smaller. Are there letter tabs in that one?
There are.
Okay, flip to exhibit L, which has already been admitted into evidence. Okay, thank you. You have the correct one in front of you. That's the white paper that I'm referencing. Is that the white paper that you referenced in your declaration in this case?
There are multiple white papers. I was probably thinking about this one, but then also one that we did late last year too. I think that this one makes a lot.
In your declaration, paragraph 32, you said in 2022, Meta published a white paper detailing its strategy for rolling out end-to-end encryption on Messenger and promoting user safety. A paper is updated in September 2023.
And this one.
Okay, so that is the white paper you referred to in your declaration, correct?
Yes.
All right. So back to my question. Isn't it true that Meta published this white paper, at least in part, to address safety issues surrounding end-to-end encryption in Messenger?
Yeah, safety is one of the tenets that we wanted to roll this thing out with, so yes.
And isn't it true that Meta intended for its current and potential Messenger users to rely upon the information published in this white paper?
Users to rely on this particular white paper?
Yes.
Probably no is the answer to that one, probably more complex. I assume some users read the white papers, but again, we do a bunch of other things to ensure users understand how to use our products and our tools.
Isn't it true this white paper is publicly available and made so by Meta? And it's made available to anyone who wants to read it, right?
They're usually posted online, yes.
And anyone who's interested in safety issues related to end-to-end encryption in Messenger could read this white paper, right?
It should be publicly available for those folks.
Okay. And so isn't it true that Meta intended for its current and potential Messenger users, among others, to review and rely upon the information published in this white paper?
Objection asked and answered.
Overruled line 30. Prior responses.
Okay, you can answer.
Can you re-ask the question, please?
Sure. Isn't it true that Meta intended for its current and potential Messenger users, among others, to review and rely upon the information published in this white paper?
I don't know if this is a perfect yes or no answer. I think that this information is there for users to access and to understand their safety, but I don't know, like, rely is a strong word there that I think it's a bit more nuanced than that.
Is there anything in the white paper that's been admitted as Exhibit L that consumers or members of the public should not rely on?
Not per my recollection, but I haven't, again, since the declaration, read it in depth. I'd have to take some time right now.
Okay. And so isn't it true that all of the information Meta chose to put in the white paper that it updated as recently as September 2023 was intended to be reliable information for the public?
Yeah, one of many sources of reliable information, yeah.
Okay. And that includes members of the public located in Nevada, correct?
Yes, public people are in Nevada.
Okay. All right, and Your Honor, I just want to preface my next few questions with an agreement regarding Exhibit 44 that council reached either last night or this morning, I can't remember, but I believe we've reached an agreement about Exhibit 44 and that its contents could be used in today's proceedings without sealing or redacting. I would just ask counsel to confirm that. And Mr. Archibong, if you could, while we're dealing with this here in court, if you could just prepare to have the larger binder ready to open if and when we ask you to do that. Thank you.
There's an agreement for Exhibit 44, so there's no objection.
Okay. Feel free to proceed. Thank you so much.
Thank you.